My name is Kate Powell, and today I'm going to talk about I-9 compliance and worksite enforcement. So just before we start, I just want to make sure that I mention it. I'm not going to discuss E-Verify program because that would take up the whole seminar. So due to the limited constraints, I'm just going to talk about I-9 compliance and worksite enforcement. So just a little bit on background of Form I-9. Since the passage of the Immigration Reform and Control Act, employers are required to verify identity and employment authorization of all employees hired after November 6, 1986. So it is now illegal to knowingly hire and continuing to employ unauthorized workers. So as part of this process, employers have to complete Form I-9, and so who needs to complete Forms I-9? Citizens and non-citizens have to complete this form, and the only exception to this requirement is for independent contractors and for sporadic domestic workers. So what documents do you need to present for Form I-9? Only unexpired documents, both identity and employment authorization documents, can be accepted. And employees might present a document from List A, which establishes both identity and employment authorization, or a document from List B establishing identity, and a document from List C establishing employment authorization. And just an example of List C document, it's an unrestricted Social Security card. So the difference between unrestricted Social Security card and restricted Social Security card is that on some Social Security cards, there is a notation that it is valid only with DHS authorization. So you would actually have to see a DHS authorization. So you may not accept restricted Social Security cards for I-9 purposes. So even though employers are not expected to be experts in documents, and they're not supposed to verify the authenticity of documents, you still have to accept documents that appear reasonably genuine and relate to the person presenting the document. The employers must retain Forms I-9 and must keep them current for all current employees. And if you talk about former employees, you have to maintain Form I-9s for at least 3 years from the date of hire or 1 year from the date of termination, whichever is later. And a little bit on corporate reorganization. So in case of corporate reorganization, the new succeeding company is not required to complete new I-9 forms. So what it can do, it can retain the old forms that the previous company maintained, but in that case, the new company will be liable for all omissions and mistakes on the original I-9 forms. So it might be a good idea for the succeeding company to complete new I-9 forms, not to be liable for the previous employer's violations. And a little bit on statistics. So failure to keep Forms I-9s will violate federal immigration laws and can lead to severe civil and criminal penalties. So if we look at this chart, you can see that in the past couple of years, there have been mass I-9 audits, and it has become a very important administrative tool within worksite enforcement. So in 2002, there were under 500 administrative arrests for immigration violations and only 25 criminal arrests. This figure has grown, and now it's more than, in 2008, it was more than 2,500 administrative arrests for immigration violations and more than 1,100 criminal arrests. So it's pretty impressive. And so when technical or procedural violations are found, employer is given 10 business days to correct the violations. Employer determined to have knowingly hired or continued to employ unauthorized workers will be subject to severe civil and criminal penalties. For example, employers may be subject to debarment by ICE, meaning that the employer will not get any future federal contracts or will not receive any government benefits, and the employer will have to cease unlawful activity immediately. And talking about civil penalties. We have for substantive violations, civil penalties range from $110 to $1,100 per each violation. And for knowingly hiring illegal immigrants, this figure is even higher. So the civil penalties range from $375 to $16,000 per each violation.
How do they figure out if it's a knowing violation?
Well, there is a good faith defense, which I'm going to talk later, which you can use to mitigate the amount of penalties. And ICE will determine the penalty amount based on 5 factors. And these are the size of the business, the seriousness of the violation, if it is a repeated violation, then good faith compliance with the regulations, and whether the violation included any unauthorized workers. So depending on these factors, ICE will determine if you will get a $375 fine or $16,000 per each violation. So next item on my slide is personal liability. The Immigration and Nationality Act imposes liability on a person or other entity. And what it means is that the Eighth Circuit has held that personal liability can be imposed on the employer and the agent. So the agent will not escape liability if he or she says that they were acting in the capacity, they were acting on behalf of the employer and not in individual capacity. And in addition, in large companies, executives with control over hiring practices can arguably be held individually liable and be criminally prosecuted. So just one more addition. Worksite enforcement audits and civil penalties, criminal prosecution are not the only concerns of the employer. When you hire foreign workers, you have to be mindful because there are still, in the INA, there are provisions against discrimination. So you cannot discriminate against the foreign persons. And in certain situations, foreign workers may bring private actions to recover damages against the employers, to file charges with agencies enforcing anti-discrimination laws, and may seek reinstatement and back pay in certain situations. So, worksite enforcement audits and employer sanctions may unintentionally discourage employers from hiring foreign workers, but the Immigration and Nationality Act has provisions against discrimination. So employer prohibited conduct under the INA includes, first of all, citizenship or immigration status discrimination. It applies to employers with 4 or more employees, and basically, employers cannot discriminate against the employee based on the immigration status. So whether the person is or is not a U.S. citizen or a work-authorized individual. As an example of citizenship or immigration status discrimination, we can say if employer has a hiring policy to prefer Americans, that would be considered immigration status discrimination. Another example of this type of discrimination is when the company is experiencing financial difficulties. If it's a slow season and your company has low profits, and you're choosing between 2 employees, the first employee, Fernandez, is a lawful permanent resident, and the second employee, Gonzalez, is an asylee who has only a temporary work permit. And you decide who you want to keep. And you decide in favor of Fernandez because he is a lawful permanent resident and he can stay here indefinitely. While this will be considered citizenship status discrimination because you may not discriminate against a protected individual asylee because the person has only a temporary work permit. So next type of discrimination protected by the Immigration and Nationality Act is national origin discrimination, and it applies to employers with more than 3 but fewer than 15 employees. Employers may not treat individuals differently because of their national origin, because of the language they speak, because they look foreign or they sound foreign. So as an example of this type of discrimination, I can say that if the employer discriminates against the person and only asks for employment authorization from a person who looks foreign but does not ask for employment authorization from anyone else, that would be considered a national origin discrimination.
Let me chime in something here real quick, Kate. Mm-hmm. You may wonder about why that has this 15 employer cap and why large employers aren't covered. In reality, Title VII, the federal civil rights statute, picks up for employers with greater than 15, and this is just supposed to fill a small employer gap. In California, the Fair Employment Housing Act is greater than 5, so we have broader protection in the state than the federal laws, just sort of FYI.
And we go to the next type of discrimination, prohibited conduct under the Immigration and Nationality Act, which is document abuse or unfair documentary practices related to verifying employment eligibility of employees. So the employee may choose what documents to present for the purposes of completing I-9 forms. So you cannot ask the person to present a DHS authorization. That will be a violation. So if the person comes to you and she says that she's here temporarily and she presents a state driver's license and an unrestricted social security card, you have to accept these documents and you may not ask for a DHS authorization. And so the next provision is that individuals filing charges with the agencies enforcing anti-discrimination laws are protected from retaliation. The employers may not threaten or coerce the individual in this situation. So how do you avoid immigration-related employment discrimination? Just some examples what would be the best practices for employers to follow. First of all, avoid using U.S. citizen-only or green card-only policy in your hiring practices or in job postings. Then never ask for specific documents from the employee. The employee is allowed to present any documents from the list of acceptable documents. So if you have a lawful permanent resident, you cannot ask him for a green card. The lawful permanent resident may present any other documents that are on list A or list B and C. So next example of good practices is that you cannot selectively verify employment authorization of certain individuals. If it's not, you have to verify everyone, both US citizens and non-citizens. And it's a good practice in order to avoid any appearance of discrimination to verify identity and employment authorization after you have decided to hire a person and allow the person 3 business days to provide you with the documents. During re-verification, do not re-verify identity documents and do not re-verify lawful permanent residents who present green cards with a future expiration date. These individuals can work here indefinitely and you may not re-verify them. Also, do not ask for initial documents presented when you hired the person. So at the time of re-verification, the person may present any other documents from the list. Do not assume that the person is illegal and try to terminate or suspend the employee without providing the employee with an opportunity to present the valid documentation. And some special rules for asylees and refugees. Asylees, when they are granted asylum, they are authorized to work here in the United States indefinitely. And they are not required to have DHS authorization in order to be eligible to work in the United States. So asylees may present an identity document and an I-94 document, and it will have a notation that the person has been granted asylum. Also, one more word about Social Security numbers for asylees. You must allow the employee to work regardless of the fact if the employee has obtained Social Security number, even though you might require Social Security for future wage reporting purposes. For refugees, I-94 can serve as a receipt only, and does not serve as a List C employment authorization acceptable document. So after 90 days, you would have to re-verify the refugee and ask him to present another document. So how do you comply with I-9 regulations? Well, first of all employers have to familiarize themselves with the handbook for employers, which is available on USCIS website. And also, a lot of vendors right now provide I-9 verification software. And employers can use this software, but the only thing about it is there are special rules regarding electronic storage of I-9s. And a lot of technology companies offering this software do not have immigration counsel on staff. So they might not comply with all the regulatory practices. So you as the employer have the obligation to comply. So you would have to still check if the software is good for your company. A good thing is to set up effective compliance system and to train workers who administer I-9 forms on proper compliance procedures. Proper training on I-9 forms and proper completion of I-9 forms will serve as a good faith defense in case of worksite investigation, or if the company is if the owners are criminally prosecuted, or if the employer is being subject to civil fines. Also, it is a good practice to conduct periodic internal audits within the company. The primary purpose of internal audits is to make sure that each employee in the company has a completed I-9 form. And at no time should the employer white out the mistakes in the I-9 forms if they find them. You have to initial and date all the corrections and additions that you make to I-9 forms. And again, internal audits are good as they can serve as good faith defense in case of a worksite enforcement audit. And in case you do not understand your obligations concerning I-9 forms, or you need help setting up an effective compliance system, or if you need help doing a periodic internal audit, or if you have a worksite enforcement audit coming to your place of business, it is a good idea to consult a competent legal counsel.